everyone, welcome back to From Laura's Perspective. You may have noticed that I recently made a playlist for all my video essays that have explained at the end. And so I've decided to make that into a whole separate series. If you're currently employed in or ever have been employed in a job, you've probably seen at least one poster in your workplace referencing the Fair Labor Standards Act. This was a law made by President Franklin Delano Roosevelt during his infamous New Deal right before World War II. As one might expect with a document that's 84 years old, a lot of changes have been made and proposed for it between its enactment and now. As such, this video will also go on my History and Evolution playlist. What other important historical documents would you like me to explain in a future video? Let me know in the comments down below. Subscribe to my channel if you haven't already, and tap the bell so that you know when it's up. Now let's get down to the story of workers' rights in the U.S. In 1932, Alabama Senator Hugo Black proposed a law which would prohibit employers from making their workers accumulate more than 30 work hours in 1 week. Even as this proposal was met with fierce resistance, Black started writing the draft for the Fair Labor Standards Act. In 1938, the year after Black left office, a revised version of Black's law was passed with a signature from President Franklin Delano Roosevelt and support from such notable figures as Congresswoman Mary T. Norton and Frances Perkins and Clara Mortensen Beyer from the Bureau of Labor Standards. With this revision, known officially as the Fair Labor Standards Act, employers would not be allowed to force workers to work more than 8 hours a day or 40 hours a week, and any worker who worked more than that had to be paid overtime or time and a half pay. This act set a minimum wage, or the lowest rate at which any worker can legally be paid, which resulted in around 700,000 American workers being given pay raises. The FLSA would outlaw child labor by setting a general minimum working age of 16 years old and an even higher minimum age of 18 for jobs that were particularly dangerous, such as mining and manufacturing. As FDR put it, the FLSA was his most important work of legislation in his infamous New Deal since the Social Security Act of 1935. Just as the FLSA was about to take full effect and really make things better for American workers, it hit the same snafu as other endeavors all around the world, World War II. Because of the war, the costs of many products made by businesses, such as factories, were drastically inflated, which forced employers to put a hold on prioritizing the rights of their workers, particularly paying them a minimum wage. By 1949, the war had ended, and this was no longer considered a problem. On October 26th, President Harry S. Truman signed the 1949 amendment of the FLSA, making its policies official. This amendment officially banned oppressive child labor and raised the minimum wage from 40 cents an hour to 75 cents an hour. But this was just the first of many changes the act would go through between then and now. Truman's signature of the 1949 amendment, the act specifically protected employees who were quote-unquote directly essential to interstate commerce and made exceptions for certain types of workers, such as retail and service workers. In 1955, Dwight D. Eisenhower proposed that the scope of employees covered by the FLSA be expanded and that the minimum wage be raised to 90 cents an hour. per an amendment that would be passed by Congress and signed by Eisenhower on August 12, 1955, the minimum wage was raised to $1 an hour. But those who worked in retail, service, and agriculture still did not have to be paid minimum wage or higher. In 1961 came about the idea of enterprise coverage. What this meant was that the FLSA would only cover employees working for a company that was both involved in interstate commerce and grossed a minimum of $500,000 a year. Per the 1961 amendment to the FLSA, all enterprise workers were automatically covered by this act, as were those working in residential facilities such as schools, nursing homes, and hospitals. The passing of this amendment saw yet another rise in the minimum wage to $1.25 an hour. As we all know, the civil rights and women's rights movements of the late 50s and early 60s resulted in the passing of laws that made it illegal to discriminate against minorities and women in ways that were once so socially acceptable. One of these was the Equal Pay Act of 1963. The EPA added to the FLSA that, essentially, employers must pay their workers, quote-unquote, equal pay for equal work. Specifically, employers were no longer allowed to deliberately pay men more than women, but rather, they had to use a system to ensure that all employees were paid specifically based on the quality and quantity of their work. Originally, EPA coverage did not extend to outside salespeople or to those working in executive professional positions. However, this coverage eventually happened in 1972 with Congress's passage of the Educational Amendments. Perhaps a result of Lyndon B. Johnson's War on Poverty, the 1966 amendment to the FLSA expanded the Act's coverage to agricultural workers and slowly raised the minimum wage to $1.60 an hour. Continuing with the theme of combating discrimination in the 1960s, the passing of the 1967 Age Discrimination Act made it illegal for an employer with more than 20 workers to refuse to hire an applicant simply because they were older than 40 years of age. This act was passed in wake of complaints from older people that they were being denied health benefits and training opportunities simply because of their age. At the dusk of the Civil Rights era, the 1974 amendment was made to the FLSA, which expanded coverage to domestic workers and to local and state government employees who had not previously been covered, and also raised the minimum wage to $2.30 an hour. By 1981, this would shoot up to $3.35 an hour. As its name implies, the Migrant and Seasonal Agricultural Worker Protection Act of 1983 required that farm labor contractors register with the U.S. Department of Labor and assure decent pay and working conditions for agricultural workers and employers. A 1985 amendment to the FLSA allowed local government employers to compensate workers for overtime with paid time off rather than overtime pay. Other employers, however, could not do that under any circumstances and had to pay employees who worked overtime time and a half pay, no exceptions. Under the 1986 amendment, or Section 14C, any employer who'd attained a special certificate from the U.S. Secretary of Labor could pay employees less than minimum wage if their productive capacity was genuinely limited by age, health conditions, or disability. Between 1989 and 1991, the minimum wage slowly raised to $4.25 an hour. In this time, a bill was passed that allowed employers to pay new employees 85% of the minimum wage for their first 2 months on the job, but if and only if this was the employee's first job. This bill also allowed small businesses with annual sales of less than $500,000 a year to pay employees less than minimum wage. In 2004, many controversial changes were made to the guidelines about to whom the rules of the FLSA do and do not apply, and which reclassified low-level working supervisors as executives, stripping them of their overtime rights. On May 25, 2007, President George W. Bush signed H.R. 2206, which enacted the Fair Minimum Wage Act of 2007. Under this act, the federal minimum wage would increase to $7.25 an hour by July 24, 2009. Per a rule change made on September 27, 2019, any employee with a salary or amount test of $684 a week, equivalent of $35,558 a year, was now considered an FLSA exempt executive employee, as well as an administrative employee and professional employee. Legally documented workers' rights have sure come a long way since the FLSA was originally enacted in 1938. But some would argue that it's still not quite where it needs to be, especially since many amendments have been proposed, particularly in recent years, that would make things better for both the employees and their employers in certain industries. And these amendments didn't quite make the cut. But one thing's for sure, the FLSA is definitely something we can thank FDR for, and it's probably the pinnacle of his New Deal. Without it, the barbaric practice of child labor would still be legal, and many workers would be getting paid even less and working in even worse conditions. How do you think the U.S. government will continue to update the FLSA in the future? Let me know in the comments down below. And subscribe to my channel and follow me on TikTok at From Laura's Perspective. And tune in next time for another explained video. Bye!